The deployment of the National Guard in California has sparked debate about its use and authority. What can the National Guard do and not do? Let me explain. The National Guard's involvement in recent protests in California has raised many questions about President Trump's authority to deploy it, with critics often citing that it is primarily the governor's role to activate the National Guard. The short answer is both claims have legal merit, depending on the framework applied. Under Title 32 of the U.S. Code, the National Guard operates under authority of state governments. While the law does not explicitly state that governors have exclusive power to deploy the Guard, it does provide the legal framework that allows states to maintain and use their own forces. Title 32, Section 109 states, "Nothing in this title limits the right of a state to use its National Guard within its borders in time of peace." This provision is the foundation for governors such as Gavin Newsom in California to control Guard deployment during emergencies like wildfires or civil unrest, unless the Guard is federalized under Title 10. President Trump federalized 2,000 National Guard troops using Title 10, Section 12406 of the U.S. Code. This section states, "When the president is unable with the regular forces to execute the laws of the United States, he may call into federal service members and units of the National Guard of any state in such numbers as he considers necessary to execute those laws." Under Title 32, command authority remains with the governor of the state. Under Title 10, command authority shifts to the president. Title 32, Section 109 outlines that states are responsible for maintaining and utilizing their National Guard forces primarily at their own expense, though this is often with help at the federal level. The Militia Act of 1903 established a precedent for federal funding of units deployed under Title 10. However, neither Title 10 nor Title 32 explicitly defines whether National Guard deployments are federally or state-funded in all circumstances. As previously mentioned, governors can activate and deploy the National Guard under Title 32. The President and the Department of Defense have the authority to command and control the Guard under Title 10. States typically mobilize the National Guard for domestic purposes such as responding to national disasters or civil disturbances. The President may deploy the Guard during national emergencies or large-scale civil unrest, as outlined in Section 12406. Governors frequently use Title 32, and this practice is widely accepted. Recent examples include state-level National Guard deployments for wildfires, or even the Capitol Hill organized protests in Seattle. Activating the National Guard under Title 10 is less common. When the president does so without the governor's consent, it can raise concerns about federal overreach. The National Guard may assist with emergency response and law enforcement support under Title 32. Under Title 10, it may be used for national defense, enforcement of federal laws, and defense against civil unrest or rebellion. However, the National Guard cannot engage in civilian law enforcement activities or act without legal justification, as specified in Title 10, Section 12406.